Hi, I'm attorney Greg Dell, joined by attorneys Alexander Palomara and Cesar Gavidia. And guys, I want to talk here and focus on disability lawsuits, but really what leads up to a disability lawsuit. We've done a lot of videos where we talk about what people should expect in a disability lawsuit, but I want to talk about how do they even get to the disability lawsuit, and maybe along those lines, it will just come out where we'll talk about ways where if they had maybe done some things that we suggest, they would never get themselves in a position where they'd have to do a disability lawsuit. So, Alex, what's the first thing that comes to your mind when you think about, why is somebody in the position where they need to file a disability lawsuit?
Well, now their claim has been denied and their appeal has been denied, and the only avenue they have left is to file an ERISA disability insurance lawsuit. Now, there's many reasons why an insurance company has denied the claim and denied your appeal. Oftentimes, what I see when people contact me once their appeal has been denied, they either did a bad appeal or they rushed an appeal. Now, I hear the horror story all the time. I heard it this morning talking to a potential client where Standard denied this lady's claim. And they said, oh, I didn't agree with it, but the doctor wouldn't change his mind. I went back to him 3 times. He wouldn't change his mind, so I have to deny your claim. I don't agree with it. But listen, email me that you want to appeal this. We'll get the appeal going immediately. The lady called me and I said, what did you do? She goes, right before I called you, I sent an email saying I want to appeal this decision. And I said, you got to email her again saying you revoked that because she just tricked you. She basically just locked you in. And what they're going to do, you went back to the same insurance company. You have no idea what the review said, what this doctor's review said. And they locked you in here. Now they're going to deny your appeal, and your lawsuit is only as good as your appeal. So it's imperative that you never rush an appeal and you do a good appeal, because it's the last chance for you to get back on claim with an appeal, and it's your last chance to strengthen your file for a potential lawsuit.
All right, but Cesar, this particular client that Alex is talking about does a bad appeal. Why can't you clean that up in the lawsuit?
So, unfortunately, in this world of ERISA group disability claims, there are rules. And one of those rules is that at the conclusion of the appeal review process, the insurance company now has made their decision on what you've submitted to them as your appeal. That closes what's called the administrative record. So that's it. The vault door closes, and you can't now submit any new records, evidence, testing, basically nothing more beyond that point where the insurance companies concluded their review process and sent you that denial letter. So those are the rules. You have to operate within the parameters of the rules set out by the federal statute, by ERISA. And when you file your lawsuit, one of the first things that is done are, after the lawsuit's filed and they respond to answer the lawsuit, is discovery. Now, in the context of civil lawsuits, discovery would involve depositions and all sorts of other sorts of litigation tools and things that we use to investigate what the insurance company did and how badly they acted. But in these cases, in these ERISA group cases, your discovery is essentially obtaining the closed administrative record, and that's what you're operating in. There's no operating outside of that.
So what you're saying is that once this decision's made on the appeal, it's over. Like, that's what's going to end up going. So what I like to think about is I don't want to lose that appeal, meaning that you want to win this appeal so that you never end up in a lawsuit. And I know that we probably win on average. I mean, we've handled thousands of these, but if you look back at our statistics as a law firm as to what we've done, we've won 75% of the appeals that we submit. But these appeals require a tremendous amount of work, a lot of strategy in thinking about what's it going to look like in front of the court if a lawsuit has to be filed. So you craft and draft, you craft the evidence that you're going to obtain in the appeal, and then you draft your appeal in such a manner that when the insurance company gets it, they're kind of like, their hands are almost tied in a way, where they're basically like, no doctor that they could go to could reasonably disagree with this evidence. And even if they did, there's no way we're going to pull the wool over the eyes of a judge who's going to find that this is unreasonable. So I think the first takeaway in this video is you've got to do a super, super strong appeal. And we have many, many videos where we talk about what it takes to do a super appeal and super strong appeal. And We encourage people to contact us with your denial letter. We'll do a free review. We'll immediately let you know if we think we can help you, and we'll tell you what it costs and what we think your chances are of an outcome. But the other thing I want to talk about is, what can people do? What do you usually see as the basis for the denial that's even getting them into the position where they now have to file an appeal?
A lot of times people don't realize that it's their duty to provide the proof of their claim. So proof is in the form of, it could be in the form of medical documentation, support from the treating providers, any objective evidence you can have, any objective testing you can get done, and submit it to the insurance company. A lot of the times the claimant thinks that they sign an authorization for the insurance company, that the insurance company is going to do it. They're going to use that authorization, gather the records to continually prove it to themselves that they have to pay you thousands of dollars per month. They might do that. They might order some records, but they're going to do a half-assed job doing it. They're not going to pay you. Your doctor sends them a bill, an invoice, they're not going to pay it. Or they're going to say that we never received it. Your doctor has they barely ever keep any fax confirmation showing that the fax went out with the medical records. So the insurance company tends to deny claims for either lack of proof or lack of documentation. So it's always your duty to provide that proof. And if you don't, you're going to find yourself denied.
And Caesar, as we're talking about the theme of what do I got to do to avoid a lawsuit, and you and I, we do appeals together every day. We just wrapped one up last night. How important is what's actually in the medical records?
It's critical. The medical records, have said it many, many times in these videos to clients, to potential clients. The medical records are your foundation. That you can't build a strong house without a strong foundation. You can't build a strong appeal without a strong foundation in your medical records and your medical file and your medical support from your treatment providers. So it's absolutely imperative that your medical records they articulate your conditions, your limitations, the struggles you're having. I know that this is sometimes challenging because what goes in your medical records oftentimes is not totally within your control. It's within the control of the doctors who are, basically putting in all of these things, all these details into their medical file, into your medical charts. But it's imperative. It's critical. You have to. And one thing I suggest is review your own medical records. Request your medical records. Speak to your doctors. Let them know who you are. Be a face that they recognize. Be a name that they recognize. When you go in and see them, make sure that what is being described in your medical records is accurate.
I always tell people, and we say, never let your guard down. Because what happens with a lot of the denials, and look, of course you get your initial denials where they apply and they just never approve them. But more often than not, we'll see denials that a change of definition when you're going from the own occupation to an any occupation, which is usually after 24 months of benefits, and that's just a change. And disability companies 6 months earlier will start to reevaluate the claim. But I think for every claimant, and we stress this in a lot of our videos, and we tell all of our existing clients, you're disabled and you think you don't have a job, but you do have a job. Your job now is to take care of yourself. And your job is to make sure that you continue to obtain medical documentation to satisfy the burden of proof for the company that's now paying you. It's not your old employer that you used to work for, it's whoever your insurance company is now. And they have requirements that you unfortunately need to follow because they don't believe you. They don't care about you, and the only thing they want to do is not pay you. So what are you going to do to make sure you get paid? You are going to make yourself look like a mess on paper. And how do you do that? You have to go to the doctor, maybe more often than you want, and continue to document it, because their mantra is, you didn't go to the doctor. You didn't take any medicine. You didn't do any therapy. You went out and did what we saw on your social media. You went to your kid's soccer game. Big freaking deal. But if you didn't go to the doctor repetitively, then they tell a story to say there's nothing wrong with you. And it's not just going to the doctor. It goes back to what you said, Caesar. Go to the doctor and make sure the doctor is documenting all of your complaints, all of your symptoms, sending you for whatever potential medical tests are out there to help justify what your condition is, and remind the doctor that you have a long-term disability insurance claim. Always think about how the other person in front of you is thinking. What is that doctor thinking when they see you? They're thinking, unfortunately, you're just another patient. I have to see 35 or 40 of you a day to make money because the insurance company is paying me now $25 per patient for each visit. They have to spend 10 minutes with you, so they can only see 6 patients per an hour, give or take. They used to get hundreds of dollars per visit. And now you want them to document their forms, your medical records. But guess what? Now they have electronic medical records that are basically required. And all of the stuff is pre-checked. And more often than not, we go through there and things are checked saying, oh, you're there for a back condition? Oh, no tenderness in the back, no restricted range of motion, no weakness. It's like you went to the doctor, but it looks like you're totally fine. And guess what the record is down the road when it goes to the insurance company? It's whatever's in your records. So it's simple things when we talk about it here, but in the reality, you got a rush doctor, you got a claimant who's the insured, who we represent, who doesn't want to go to the doctor to begin with. 9 out of 10 times is just going to the doctor just because the insurance company is making them go because they know what they have. It's a chronic issue. It's not going to get better because if it was better, the claimant would be working. So it's like this vicious cycle, but it's easy to protect yourself. It's the reason we have this protect your benefits theme, in our studio, and it's everything that we do.
Yeah, Greg, unfortunately, it's difficult and challenging by design. That's how it is with these group disability insurance policies and claims because they know, and I'm certain of this, insurance companies know that these doctors do not want to spend time, most of them, completing insurance company forms, being challenged about their findings, their conclusions, their opinions, having to take time out of their busy schedule and day to speak to the insurance company people or their doctors. And many of them, all they want to do is go into their practice, see their patients, assess their patients, hopefully resolve their problems, and leave for the day and get back to their families in the evening.
Yeah, and that's, so look, we've identified a lot of things that you can do, and when we manage claims for clients, we then do the appeals and go back to the client and resurrect all of the evidence and get the doctor to articulate his opinions. But you don't have to let it reach that point. You can do it on your own, which is why we do these educational videos to let people know, hey, avoid these denials. Or if you want help with the claims, we'll do it for you. It's a minimal fee that we charge to manage these claims on an ongoing basis. Yes, it gets expensive if you get denied because then there's a lot of work to do and we got to rewrite the script. But you can keep yourself from not having to get to a disability lawsuit, which is the entire theme of what we're trying to say here in this video. So if you're out there, no matter what stage you're at with your claim, feel free to contact Caesar, Alex, myself. No matter where you live in the country, we have an army of attorneys available to assist you. We will review your claim, your policy, your denial letter, whatever stage you're at, and we'll let you know right away if we can assist you.